So we are going to continue our discussion of cases and court opinions, and we're going to focus primarily on citators, at least for the first half of class, and then we'll talk about other types of case materials in the second half. And of course, by citators, you're probably most familiar with what? What do you think of when I say citators? No idea. To talk about shepherds and key cite in legal writing and maybe some other. Those are citators. What do I mean by a citator? Anybody want to hazard a guess? I know we're heading into spring break. Hang in there with me for just another couple of hours. I'm with you, trust me. No guesses. Okay, so citators, what it sounds like. Places that you find that will tell you where stuff has been cited. Technical term there, stuff has been cited. We've already actually been looking at citators. So here we see Westlaw, and we've been talking about one function of a citator, which is, of course, updating, or, excuse me, I should say updating, updating, and updating. So that's function number one of citators, and we were talking about when looking at statutes, looking at the flags and making sure that nothing has happened to our statute to make it no longer valid. So by nothing happening, of course, getting amended, getting repealed. But also there are cases, because of course we exist in a common law system, and judges can say that a statute is unconstitutional. But probably the most important thing for today that you should remember is that when we are talking about invalidating, you need to be more specific than good law, bad law. You need to be more sophisticated and nuanced than good law, bad law. You need to think about what these red flags and yellow flags are actually doing. And this is true whether we're talking about statutes or cases. So here we have a great example. Actually, Jessica and I had a great email exchange about this, where Jessica very wisely noted, oh my goodness, this is a red flag. Can I be citing to a statute that's bad law? And probably that's how you learned it in legal writing. But what you need to look at is a more nuanced, you need to use a more nuanced approach. So here's this red flag. It's saying unconstitutional or preempted. So that makes sense. It sounds like this is no longer good law. It's held unconstitutional and not severable, and it gives you a reference to a case. So the first thing you want to notice is, okay, this case is from the Northern District of Texas. Does this case apply all over the country, because this is a federal statute? So what you need to always do is check out what exactly the case is saying about your statute, or when we get to talk about cases treating other cases, what it says about your case. And the only way to do that is to go to the actual statute. Now, this turns out to be a fairly complicated question. That's why we had quite an interesting exchange. So this Texas v. United States actually overruled the ACA, the Affordable Care Act, also known as Obamacare. And so as I looked at that after Jessica emailed me, I thought to myself, I've been reading about Obamacare. I don't think that's been overruled. I kind of would have heard about that. That's sort of major. You know, we've had at least one major Supreme Court case about it, right? And it's always in the news, and Congress has been voting on it a whole bunch of times. And so I took a look at the case, and sure enough, not only does this judge say he's overruling it, but he's saying it's not severable. So that's the first thing you want to think about. So this judge is saying that the ACA, that the particular section that he's finding of the ACA isn't severable for the rest of the ACA. So this judge is overruling the ACA. So the first thing you need to think about, going back to our original question, is this statute still, quote unquote, good law, valid? And the portion you would need to track through the ACA, or track through the reference here, to determine where the ACA changed this statute, because this is talking about misbranding food, right? The Affordable Care. So that tells me that there's a section in here. So basically, the bottom line is this judge is overruling the ACA. What part of the ACA makes up this statute? And the answer is, it turns out it's very little. And yes, you'd have to track through that to understand that, and it took me a little bit of time to do that. But that tells me, first of all, that as portion, if a judge holds a statute or if invalidates a statute, when you're looking at your code section, what part of the code section involved that statute? And it turns out this particular, our section 343, only one small part of it has to do, or came into being from the ACA. It has to do with labeling, actually. And to be honest, how did I figure all this out? I could have gone through and figured out the public law of the ACA and figured out this section, how we all walked through that process with statutes, or I could look at secondary sources, which is what I wound up doing. And I just honestly Googled the ACA in this case and found a reputable site and read up on it. So I learned that, okay, first of all, the ACA, what it did with regard to this was labeling. But the other thing I learned about is that this particular case was, the holding was stayed. Obviously very controversial issue these days, healthcare. So the moral, well, two morals of this story. First moral of the story is it's good to be aware of what's going on in the world, because that will inform your what do I have to research question. So knowing that, about the ACA and knowing about these cases and the Supreme Court helped me to realize, okay, I need to get some background. The second, and back to what I hope you walk out of class today remembering, if nothing else, is that you need to take a nuanced approach, because that case only affected one small subsection of this statute section. Whatever subsection, it doesn't really matter. The rest of it had nothing to do with the ACA, so the rest of it is still valid. And what you will often find when you see these flags is that they're really applying to only one portion of a statute or one holding in a case that may have several holdings. And yeah, it takes some digging to go through all of that, but you need to do that, because if you saw the red flag and say, oh, red flag, not good law, you would miss an important section for your client's issue. And even if the section that the ACA, even if that does get overruled and is no longer valid as part of this, as a subsection of part of the section, it doesn't really matter, because it has nothing to do with, actually it's the nutrition information. So I mean, that's kind of related to your client. But I think the nutrition information, I think it has to do with calorie counting. Now that as I'm remembering, yeah.
So when you're citing it, would you note that although it's been overruled for something, it's still valid for what you're using it as, or you just use it?
I think for statutes, if you're citing to a particular subsection, as long as that's still valid, you just cite to it. If you're citing to the overall rule, I think you still cite to it. Cases, a different story, and that honestly is more of a blue book issue. I think you usually, the blue book rule is that you usually do state that it was overruled in part on another issue. Don't quote me on blue book rules. I'm sure many of you are far more expert on blue book than I am. Okay, so again, just to recap, so subsection of this section possibly overruled, although that on further investigation I learned that ruling was stayed. Subsection having to do with calorie counting, which is not what our client's talking about, so you don't care anyway. So again, much more nuanced than seeing a red flag and thinking it's not good law. In fact, we should probably erase that phrase from our vocabulary and think more about, is this section valid for what we're citing it to? Is a case valid for the holding we're citing? Or is the holding valid? Okay. And interestingly, this particular section, if you take a look at it on Lexis, so same exact section, Lexis gives us that's an exclamation if you can't see it from the back because that screen isn't the clearest. But if you take a look at the Shepherd Eyes report, And then, of course, Lexis has our different analyses. So it says here, unconstitutional in part by, and we take a look at what those cases are. It doesn't even mention our Texas case, interestingly. I'm guessing, I don't know for sure, but I'm guessing that's because Lexis has determined that that Texas case hasn't ruled this unconstitutional yet, even the subpart that we're not interested in. So there are differences. That's not to say one is better than the other. It's just to point out that there are differences. And again, just to look at a state statute, same concepts apply. And interestingly, this is a yellow flag saying unconstitutional preempted. And this is probably what you're going to run into more often, the whole ACA question. That's an unusual situation because that is such a controversial and ongoing question as in terms of litigation. But you will see this occasionally, and I've seen this in different code sections, unconstitutional or preempted. And of course, we've been talking about preemption for ERISA. Turns out there are a lot of federal statutes that preempt state law for certain issues. So if you take a look at this Copeland case, you would find out that this is preempting state law on either a banking issue or an insurance, not an insurance issue, on federal employees, I think it is. So, and our client isn't a federal employee, we're not talking about banking, but you need to, and Lexis and Westlaw make it pretty easy. You can get into the case and see where your section is cited and just read it fairly quickly to see how it treats your particular statute section. And same is true on Lexis. But actually, I don't even pull that section up, it doesn't matter. Okay, so any questions about updating, and updating when we're looking at flags for code sections? Okay, so let's dive in and talk about updating, and updating for cases. And again, citators serve two functions. I've talked about the updating function. The other function citators do for us is a research function, especially mostly for cases, not so much for statutes or code sections. So let's take a look at that, and I'm going to try something a little bit different today in terms of a workshop. I'm going to ask you to move into teams of 2, so that way you can work together. And what we are going to, so if you could just figure out amongst yourselves, you just move over so that they're 2 to a table. And what we are going to do while you're doing that is we are going to use, actually let me go back over here so I can show you. Where did this go? Here we go. Okay, so I don't know. You want to, yeah, move back or come on, get a little stretching in. I know, it's mean of me to make you get up and move. So when you log into Lexis, of course, you've been logging into Lexis and either going to Lexis Advanced or going to Lexis Classroom. We're now going to look at Lexis Learn, and these are little tutorial videos on different aspects of research. Now, what they've tried to do on Lexis is, even though they show you the examples on Lexis and we will do the tutorial using Lexis, they give you the concepts that really apply to either Lexis, Westlaw, and to some extent Bloomberg. So the modules we're going to walk through together, and you and your various teams as a group is, we'll take a look at Module 6, making sure you're citing good law. And again, I don't like that term, good law, but they'll actually talk about that. And then we'll do Module 7, finding more authority from a case. So really it's the updating function and then the research function of our citators. So we will go to... So so if you want to follow along, although I'll ask you to turn your volume off, because otherwise we'll have the volume in all different spots and it'll be cacophony. You can go to the Lexis Learn and go to these modules. I've set up a class, so you'll see Citators under my name, or you can just watch on the screen, because I'll be stopping and using the screen to go through class. So the first thing I'm going to do, and if you could all just not do this on your laptops, is we'll play the hypothetical, so we all know what our facts are. This is about a minute and a half, and then we will dive into the module. And if all goes well, the volume will work. Here we go.
Mr. Thompson came under suspicion after stealing a beekeeper suit and a large pile of sugar he used to steal a swarm of bees from an apiary close to his home. Local law enforcement officers believe that these smaller crimes were committed by Mr. Thompson as a part of a larger plan to manufacture and distribute cocaine from his hometown of Cape Fear, New York. Officers obtained a warrant for a 1-month period to track Mr. Thompson's movements with a GPS device attached to his car. Finding no evidence of drug trafficking during this period, the officers continued to use the GPS device after the warrant expired. Mr. Thompson was later tracked going to and from the location of a known cocaine distributor several times. On the day of his arrest, Mr. Thompson was returning from the same location. The officers stopped Mr. Thompson's car and found 10 pounds of cocaine hidden in the trunk. You've been asked to draft a memorandum recommending the charges that can be brought against Mr. Thompson based on relevant criminal statutes and case law. The district attorney is concerned about Mr. Thompson's case because the warrant had expired when the evidence of Mr. Thompson's drug activity was discovered. Mr. Thompson's theft of the sugar, bees, and beekeeper suit was documented by officers based on statements from the apiary owner.
Okay, so there's our statement of facts. Let's go back, and so we will start making sure you are citing good law. Now, all of these different modules on case research, secondary research are based on that same hypothetical. If you decide you liked this, you can go back and look at those as well for a refresher. So let's get started. So the way this is going to work is this video is going to play and it will stop with questions. I'm going to ask each of the teams to come up with an answer, and then I will either ask for a volunteer team or we'll just vote.
Throughout this module, questions will surface, giving you a chance to review the information covered. Use the legal research system below the video player to locate the answers. After you found the case law and code sections to support your conclusions, you need to make sure that the authority you're relying on has not been reversed or overruled. To properly validate the cases and code sections you find, you'll need to use a citator. With case law, citators show you the history of a case and help you to evaluate the strength of its holdings.
Okay, so citators are used to check the validity of cases, statutes, and regulations. How many vote for true? Okay, and how many vote for false? Okay, so let's go for true. Hey, so far so good. A tool that helps determine what has happened in case, statute, regulation after it was released. This helps you determine if the case is still valid and therefore citable.
Shepard's is a citator. Validation checking is a legal research step you never want to skip. Here's why.
Never.
In this case, we have no newly discovered facts with respect to the motion for reconsideration of Laura McKinney.
Doesn't the case law dealing with that particular code section include criminal cases? If you Shepherdized it, you can use a criminal
We
case.
did. I believe that none were found, Your Honor. We don't have any in our motion. which leads me to believe that no, there aren't any criminal cases under that section. And you asked that question because you knew the
Passing the buck there.
No, as far as I know, there are no criminal law cases that involve that section because it's not recognized in criminal law. So, I mean, at least in theory, we didn't have to have all the arguments. But
So my Pepperdine Law Clerks found some.
did they? Criminal cases? And what do they say?
Say it's applicable in criminal law cases.
Okay. Nevertheless, you don't have any.
Now
You feel for that poor associate?
validate your research. Let's look at how to do it effectively. In the Thompson drug and theft prosecution, it's not in dispute that Mr. Thompson took the beekeeper suit from the person of the apiary owner, but a question has arisen in your research about the nature of Mr. Thompson's taking that will affect his sentencing if convicted. Specifically, should the taking of the beekeeper suit be considered a violent felony, requiring the classification of a crime to be included in the charging papers for sentencing? The district attorney was not aware of any such ruling in the Second Circuit. He referred you to a case from the Seventh Circuit he is familiar with on this topic, United States v. Lee. He wants you to use this case to find a similar ruling in the Second Circuit. Lee's two principal holdings say that theft from a person is not a violent felony and that the classification of a crime must be included in the charging papers. When you pull the case up, you notice it has a red stop sign next to the case name. This warning symbol indicates that Lee is no longer good law for at least one point of law discussed in the case.
Okay, so here's what we'll ask teams. Pull up Lexis and pull up your answers, and then I'll take the votes of the teams and we'll see how we do. So according to the Shepherd's report for U.S. v. Lee, 22 F3D 736, how many other cases have questioned a ruling from Lee? You get to ask questions. So give me a wave when you have an answer. Okay. So you're going to Lexis, you're pulling up 22 F3D 736, opening Shepherds. Anybody need more time? Okay, so how many vote 0 to 2? Okay, how many vote 3 to 8? Okay, so Steffi Rosa, did you find an answer? Oh, okay. All right, so it looks like 3 to 8 has the majority. We will submit. And that is correct. So let's walk through questions.
Oh, we're going to walk through a set of questions about it.
Okay, so let's walk through it. So here in Lexis Advance, I'm pulling up the case. So it's just at the top here, 22 F3D 736. Okay, so team here to my left, Danielle and Jessica. What do I do next? Shepherdize this document on the right. And then, so this cuts off our questions. So it asked us how many questioned. So we see questioned, and it came up with 3. Your question.
I just don't know why it said 3 to answer is 3.
Because it's giving you a range. I don't know why they chose their ranges.
Okay.
That was...
I didn't know if it was like, including caution and warning or whatnot. I just didn't know why it was giving us a range.
Fair enough. For these questions, take them very literally. I think they were just, I don't know why they gave you those choices. Okay, does that help you in the back? Because if I remember correctly, there are more questions on this particular case, U.S. v. Lee. Okay, are we ready to continue?
It doesn't mean that your case is bad law and therefore
Very important.
uncitable, but it does mean you'll want to be very careful with your use of this case. These signals do not evaluate the validity of an entire case. Instead, they attach to points of law in a case and alert you to the way subsequent decisions have analyzed those points of law. In short, you don't validate cases to determine if they are good law. You validate holdings from cases to make sure they are still citable authority.
Okay, super important. This is like the theme for today. You can determine the validity of a case by viewing the signal attached to it. How many say true? How many say false? Yay! Okay, I've accomplished most of my goal for today. Signals do not evaluate the validity of an entire... Can you read that from the back, or can you guys read it in the back? No, okay, so then I will read it. Sorry, up there in the front. These signals do not evaluate the validity of an entire case. Instead, they attach to points of law. So instead of thinking of good law of a case, think of points of law in the case. That's me. That's not what that's saying. Of law in a case, and alert you the way subsequent decisions have analyzed those points of law. You must read the opinions to determine the effect on validity. Makes sense to everybody. Like I said, this is probably the key concept I'd like you to walk out with. Ready to continue?
Remember, there are 2 holdings from the Lee case you are researching. Holding number 1, theft from a person is not a violent felony. Holding number 2, classification of a crime must be included in the charging papers. Validating Lee takes you to a Shepherd's report with separate sections for appellate history, citing decisions, other citing sources, and table of authorities. When determining if a holding is still valid, you will need to review the appellate history and citing decision sections of a Shepherd's report. There is no appellate history for Lee, but it's important for you to see how the appellate history works. So let's take a quick look at an unrelated case with a straightforward history. Worldwide Volkswagen. The appellate history contains the Supreme Court of Oklahoma decision that was appealed to the Supreme Court of the United States. The second case listed is the Supreme Court of the United States decision that reversed the Oklahoma decision. This is your case, Worldwide Volkswagen. What follows are the subsequent decisions that could affect the holdings in Worldwide Volkswagen. When you're using Shepherd's to determine if a holding from your case is still valid authority, these subsequent decisions are the most important cases for your review.
So again, these subsequent decisions in the litigation chain, cases that are related within the litigation of whatever case you're looking at, in our example, Worldwide Volkswagen. So which are the most important decisions from a case's appellate history when validation checking? So we've got prior decisions, subsequent decisions, indirect decisions, none of the above. So who votes for prior decisions? 0. How about subsequent decisions? Everybody. Anybody go for indirect? I think it was everybody. None of the above. So let's take a look at subsequent. Yay! So when you're using Shepherd's to determine if a holding from your case is still valid authority, again, we're getting rid of that good law language. It's still valid authority. Subsequent decisions are the most important cases for you to review because they can affirm, invalidate, or reverse the case you are validating. Ready to continue?
Another way to review a case's history is using the appellate history map. The appellate history map is a visual representation of a case's path through the courts. The legend menu explains the graphics used in the map. Clicking the links in the map provides you a quick look at the case information.
Okay, so according to the appellate history map, where did the later proceedings take place in the worldwide Volkswagen case, which is 444 US 286? So you want to go to 444 US 286, go to the Shepherd's Report, the appellate history, and find out where the later proceedings took place, in which level court. So I'm just going to the case, I'm pulling up Shepherd's. And then this little pie thing here. Oh no, not the pie thing. Sorry, I'm getting ahead of us. We want to go to the map. That's what I did wrong. Thank you. Now the pie thing should give us map view. There we go. Thank you. So, what level court? Okay. Who votes for the Supreme Court? Okay, so we've got one group. How about federal intermediate courts? We've got 4 or 5 groups, 6 groups. Trial court? Administrative agency? Okay, so it looks like we have mostly the federal intermediate courts, and that's correct. And we'll take a look at why in a sec. The later proceedings took place in the 10th Circuit. They are listed in the federal intermediate Court of Appeals level in the appellate history map. Okay, so
now let's
wait, we want to pause. So down here, it's going to let me scroll. So actually, you guys are sort of right, because the later proceedings here were in the appellate courts, and then a later proceeding, and then once again a writ was granted. So I could see where you would think that that was correct. I actually agree with you. Literally, that's correct. But so is also the federal intermediate court. Everybody see? Okay. Whoops. Okay.
Analysis of the holdings from the Lee case by looking at the decisions from the other courts that have analyzed the Lee case under the Citings decision section of the Shepherd's Report.
So now we're moving to citing decisions. So outside the case's litigation.
You notice that the red stop sign appears next to the link for citing decisions. This tells you that the negative analysis for the holdings from your case can be found in this section of the Shepherd's Report. First, let's narrow this report to the cases analyzing holding number 1 from Lee. Theft is not a violent felony. Using the Search Within Results filter, you can quickly search the citing decisions for mentions of violent felony.
Okay, so use the analysis filter. So we're going back to US v. Lee, and that's 22 F3G 736. and then use the analysis filters in the Shepard's report to determine which of these decisions analyzing Lee mentions violent felony and questions a holding from Lee. So you're going to use two different filters, and there I'm giving half of it away already. So that's where I want to go. Okay, so 22 F3D 736. Sure. So using the analysis filters to determine which of these decisions analyzing Lee mentions violent felony and questions a holding from Lee. This one's a little more challenging. Give me a wave when you think you got it. Okay. Zainab, is that a wave or a stretch? It's a stretch. Okay, give me a wave when you think you've got the answer. Okay, so we've got one vote for Taylor. Anybody else need more time? Are we all done, or do we need more time? Okay, so we've got one vote for Taylor. Who else? What other groups vote for Taylor? Okay, just about everybody else. Steffi, Rosa, you got a different group? Different. So US v. Taylor, US v. Smith, US v. Davis, US v. Martin. Alex Maffey, you have a different vote, or you're voting for Taylor? Taylor. Okay. So, Alex Maffey, can you walk us through and how you got there? So I'm here at US v. Lee. I'm going to Shepardize. Okay. Okay, so search within results for violent felony. Click on question. And that's where we see US v. Taylor. So, Steffi, Rosa, would it help you to move up a couple of rows so you can see the screen? Unfortunately, that's the best resolution I can get. Okay, so US v. Taylor it is. Ready to continue?
To check the validity of a Lee holding regarding theft, you need to review the cases that analyze Lee negatively. Under Analysis on the left, you can see there are 2 cases overruling a holding from Lee, 2 cases distinguishing themselves from a holding in Lee, and 1 case criticizing a holding from Lee. In all, you have 4 cases to review because 1 case both distinguishes and criticizes Lee. Click the warning link to see the case overruling a holding from Lee.
Okay, so once again, let's use the analysis filters to find a case that mentions violent felony and criticizes US v. Lee. We ready? Okay, so what teams vote for U.S. v. Martin? We're not, do you need more time? Okay, what? Who votes for U.S. v. Martin? How about U.S. v. Payne? Looks like everybody, all right? Great. U.S. v. Payne both discusses violent felony and criticizes a holding from Lee. So let's go down, and we got there how? How about guys?
Well, we did something similar to before. You scroll down to search for the results.
Okay, I already actually did that. So we've got, so you search for what? Okay, so that's what I already did. So that's what I've got here. Okay, so what's the next?
On the left-hand side, click criticize by.
Okay, so same idea. So you search for the text of your holding, and then you search for the negative analyses, and here's U.S. v. Payne. Excellent. Ready to continue?
You can see that United States v. House both overrules a holding from Lee and follows a holding from Lee. Click the link for the House case and scroll through the case using the references arrow. You can see in this paragraph that House overrules the Lee holding that theft from a person is not a violent felony. But House follows Lee's holding regarding charging papers, even going so far as to say that Lee's holding regarding charging papers remains good law. So the case from the 7th Circuit that the district attorney referred you to has been overruled by United States v. House for a holding important to your analysis, specifically that theft from a person should be considered a violent felony. You'll still need to read the cases that distinguish and criticize Lee's holdings if they're from the 2nd Circuit to be sure. But it appears that based on relevant case law, Mr. Thompson's theft of the beekeeper suit should be considered a violent felony, and that classification must be included in the charging papers to preserve it for sentencing.
Okay, so which of the cases that mention violent felony and distinguish themselves from the Lee case has a deeper discussion of Lee? We really didn't go over discussion levels, but you can see the discussion levels here on the right. Okay, have your answers? Okay, who votes for U.S. v. Payne? Okay, just about everybody. And anybody for the other case that I really can't pronounce very well? Okay, nobody. Good, so I don't have to say it. Let's see what U.S. v. Payne. Yeah. Okay, so going down, what I wanted to show you, I won't make you walk us through, but I first did the search within results filter for violent felony, which is what we've been working with. And then for the analysis, so I could see all of the negative analysis, I went to select multiple. And then I just clicked off the negative one. So warning, questioned, and caution. and then just basically clicked on OK. And so I got all of the different negative analyses, and from there I found the answer. I also wanted to take a look at that because that's how they came up with that US v. House case, which overruled the Lee case in part for one of the parts that we're interested, the violent felony. All of that makes sense. No? Yes? Maybe? Yeah.
Didn't the High Court say that this is Second Circuit?
Yes.
So we're using this as persuasive because it's the second?
Let's get to the end of the video and then I'll answer that. Excellent question, though.
Now you need to find a similar case from the Second Circuit because United States v. House is not binding in your jurisdiction. The good news is that you can use the House case to look for similar cases from the Second Circuit. In the Finding More Authority from a Case module, you'll learn how to do just that with Shepard's using the citation spread, headnotes, and the table of authorities.
Okay, so let's go to that end. Jessica was not a plant. I did not ask her in advance to ask that question. Okay.
Throughout this module, questions will surface, giving you the chance to review the information covered. Use the legal research system below the video player to locate the answers. When starting a research project, you may be given a leading case or statute related to the issue you're researching. Or, early in the research process, you find a relevant case or statute. In either situation, there are some excellent tools that help you quickly find more authority from just a single document. But you might be wondering, if I've already found a relevant case that's still good law, why do I need to find more cases? When finding authority to support your argument, ideally you want to cite the most recent on-point cases from the highest court in your jurisdiction, as these carry the most weight. More recent cases may explain, expand, or slightly alter the analysis in the first case, and should be evaluated as well. The tools we'll explore in this module help you efficiently locate the most recent, on-point cases for your jurisdiction. You've determined that Mr. Thompson's theft of the beekeeper suit should be considered a violent felony, and that classification must be included in the charging papers to preserve it for sentencing based on a holding in the Seventh Circuit case, United States v. House. However, House isn't from your circuit, so you don't want to rely on it as controlling authority in your case against Mr. Thompson.
Buffering. All right, we're going to have to reload. See if I can skip ahead.
Then a leading case or statute related to the issue you're researching. We don't want to rely on it as controlling authority in your case against Mr. Thompson. Site-checking House is an efficient way to find similar authority on your issue in the appropriate jurisdiction.
You all journals use it differently, but this is another usage.
Click on Shepherd-ize this document to the right of the case. You have 4 options on the top left. Appellate history provides the events in the litigation chain of your case so you can follow its path through the court system. Citing decisions lists the cases that have cited your case and how they treated your case. articles, treatises, statutes, court documents, briefs, pleadings, and motions, restatements, and other secondary sources that have cited to your case. And Table of Authorities provides a helpful and convenient listing of all authorities, both primary and secondary, cited in your case, and indicates Shepard's treatment symbols for each of those cases. Citing Decisions displays all the cases that cite your case. The default view lists cases from highest court to lowest court. To see a graphical view of your citing decisions, select Grid, top right. The top grid displays level of analysis by jurisdiction, and the bottom grid shows level of treatment over time. The grid view helps you quickly identify jurisdictions that have heavily cited your case and how they treated it, and uncover trends and see a streamlined view of how your case has been treated across the country.
Okay, so what federal circuit court has the most cases citing U.S. v. Howes, which is at 343 F. 3rd 919? Have an answer? Okay. Votes for the First Circuit? None. Votes for the Sixth Circuit? None. Votes for the Seventh Circuit? Unanimous. Okay, so a couple of things I want to point out before we go forward. So basically here in citing decisions, guessing you all went to the grid thing, what I like to call, or the pie, and you found that the Seventh Circuit had the most. The mistake I made earlier, which Jacqueline very kindly helped me out on, was the appellate history. So the litigation chain of your case, the litigation chain of U.S. v. Howes. If you go there to the grid thing, you get the map view. And one thing I wanted to mention is I wish I had this back when I was a first year in Civ Pro, because when I used to get asked, you know, what was the chain and how did your case get to the court it was going at, I would have found this to be a whole lot very helpful. It's, of course, now not coming up for me. We seem to be having some internet issues, but that's okay. But you saw the map before. So just as a thought for future, if you ever need to trace that back, think about these maps, and I'll show you how to get there on Westlaw as well. Okay.
Notice there are two cases in the Second Circuit that cite Howes. The one in green follows one or more holdings in Howes, and the other case simply references Howes. Let's look at the case that follows a point of law in Howes. Click on the green box for positive analysis in the Second Circuit column. When you click on a specific page reference, also known as the pinpoint page, you're taken to the point in the case where your case is cited. This case from the United States District Court for the Southern District of New York references Howes in the context that 7 United States Courts of Appeals have held that larceny from the person presents a serious potential risk of physical injury to others. Now you have a Second Circuit case in addition to the Howes case supporting the argument that theft from a person is considered a violent felony.
Okay, so hopefully this is an easy one. Citators can be used to find more authority addressing a legal issue. True? votes for true? Okay, head shaking's okay too. Any votes for false? No votes for false. True it is, and it's even efficient.
You also need to find additional authority related to another issue you're researching on the Thompson drug and theft case. You can do this by finding citing references that refer to a specific headnote. Mr. Thompson was arrested returning from a known cocaine distributor with 10 pounds of cocaine in his trunk. The arresting officers used a GPS device attached to his car to track Mr. Thompson's movements. The warrant for the GPS tracker expired before any evidence of Mr. Thompson's drug activity was discovered. After consulting a secondary source, you found a key case. United States v. Jones.
Okay, so in U.S. v. Jones, which headnote addresses whether a GPS device attached to a vehicle for monitoring purposes constitutes a search? And you will find U.S. v. Jones at, I'm going to see if I can, well, you'll find it at, I'll write it down, 132 SCT 945. And I'm going to get myself there as well. 132 SCT 945. And the question is, what headnote in that case addresses whether a GPS device attached to a vehicle for monitoring purposes constitutes a search? Okay, we there? Anybody need more time? Alrighty then. So, headnote number 2, votes for headnote number 2. Votes for headnote number 3. Everybody, headnote number 3. Let's. Yep. Headnote number 3 states government's installation of a global GPS device on a target's vehicle and its use of that device to monitor the vehicle's movement constitutes a search. That's headnote number 3.
The Jones case makes it clear that the use of a GPS tracker without a warrant violates the Fourth Amendment's prohibition against unlawful search and seizure. But it's important to see if there are any more recent cases that support this position, which you may want to cite. You also want to see if any subsequent cases have taken a different position on the issue. Let's see what additional authority we can find on this issue. You see that the point of law in headnote number 3 states that installation of a GPS device constitutes a search. To quickly find more cases addressing this issue, click on the Shepherdized Narrow by this headnote link. Now you are viewing a list of all cases that cite U.S. v. Jones in reference to the point of law stated in headnote number 3. The filters on the left are available to help you further refine this list of cases.
Okay, so what is the U.S. Supreme Court case that relied on U.S. v. Jones to support its Fourth Amendment challenge on appeal on March 30th, 2015? It's a little tricky. So U.S. Supreme Court case that relied on yours. Okay.
Like a literal different question.
It says, what is the name of the New York Court of Appeals case?
Yeah, that's something funky in the Lexis Learn. We're actually going to stop before we get to the end because there's something wrong in the video.
Oh, so it's okay that we're not on the same question.
Yeah, I don't know why it does that. It's a flaw in the Lexis video. So as I said, we were going to answer this and stop in like a minute. So, no, you did not. Lexis did. Yeah. I mean, go ahead and answer that one if you want. It's thinking it's the same concept. I haven't read the question in a little while. Okay, we ready with an answer? So, votes for Florida. B. Jardines, I guess. Votes for Riley v. California. Votes for Grady v. North Carolina. Looks like we have near universality. And that is it. And we did that how? Michael and Yaroslav, you want to walk us through?
Sure. You go down to the head note.
Okay.
Go down to shepherdize.
Head note.
Yeah, shepherdizing narrow by head note.
Number 3, right? Okay. And then?
I think it was for both-sided. So you take the one that you can narrow down by sided.
By sided. So up here?
Yeah. So they ask for sided. So because I have the other question as well.
Oh, okay. Anybody else?
We did followed by.
Okay.
And then U.S. Supreme Court.
And there it is. Excellent. Okay. Given the funkiness, I think this might be the place to... Yeah, well, when I did this earlier, it did the same thing just past this point. I was actually just going to stop. So you know what? We're done. Enough of flip-flopping questions. And we got as far as I think is important. I also had it putting in questions in the middle of while the video was speaking. So there's something funky in the video. But more importantly than Lexis and its video making, do you have a sense now of how the difference between validating a holding, or as I like to say, updating, where you're looking at the negative treatments, and the research function where we're looking at the head notes and the just the how to move between different jurisdictions? Okay. So that's essentially why we use citators. We got a good introduction to Lexis. I'm going to show you one more feature that's relatively new, so that I think they haven't incorporated into the video yet, but they're very proud of. And I think it's kind of neat, so it's worth showing. And here back, this is a different case altogether. Rush Prudential, HMO. We've actually run across this when we've been talking about our insurance HMO issue. And what the new feature is here on the right, you see reason for shepherd signals. So what Lexis is pulling out is essentially what they call the top citing references. Why did Lexis decide this deserved a red stop sign as opposed to any of these other signals? And it gives you the major case if you eventually get to in the context of, I'd like to get there, in the case that caused the red signal, and you get to the point in that case where you see the language that Lexis determined was the reason for this signal. We're having technical difficulties here more than just funky videos.
I thought would be
Sorry.
We broke it.
We broke Lexis. Okay. Well, I'm going to leave that there for now, and let's look at Westlaw. Pretty much the concepts. Yeah, question.
What is like the pricing of all of that? Like, is this a thing that if you have cases, you're also and Shepherds, you're getting all of this? It doesn't matter how many times you're clicking on stuff.
It depends on what documents you click on. On Lexis, Shepherds, going into Shepherds doesn't cost anything, but if you then click on a case, that will cost a case view.
Okay.
And I believe in Westlaw, key site report does cost, not a lot, but does cost some amount of dollars, and then going into a case will also cost more dollars. So here in Westlaw, looking at a case, again, we see the flag and all of my caveats regarding being very careful how you interpret that flag applies on both systems. What we would have seen on Lexis is a different case overruling the Rush Prudential case. But if we click on this Clay case, and I know you can't read the print, so you'll just take my word for the name, the Clay case, that's the flag here is saying overruling recognized by. So it's telling us that the Clay case recognizes the overruling of Rush Prudential. And actually, that's not the... So if I click on the case, I just get to the case. So don't make the mistake I just did. Learn from my mistakes. If I go to the flag, I'll actually go to the point in the case where it mentions Rush Prudential, which is what I wanted. And hopefully Westlaw will work for us, I think. And so what you see here is a listing, and Westlaw will tell us the most negative. And going to the text where Rush Prudential, our case, is mentioned, I hope. So what it tells us is Rush Prudential, so it's telling us to see also Rush Prudential, and it's giving us something about arbitration constitutes alternative remedy litigation, and then it's telling us overruled in part on other grounds. So, Danielle, there's your citing in a case that this was overruled in part on, the decision is recognizing this, but it was other grounds. And I guess that's the official Blue Book terminology. And the case is Kentucky Association of Health Plans. That would be the case we would have seen in Shepherds if Shepherds was working for us. So again, just be and I like to show this language because this is a very good example of why you don't see a flag and say, oh, it's not good law, because they're saying it's overruled on other grounds. It still applies for the argument that we're discussing. Okay, so let's get back to Rush Prudential and talk a little bit more about using Westlaw as a citator, both for validating holdings or invalidating holdings, and as well as for research. And essentially, key cite, Westlaw's citator, are these tabs that we've already been looking at. So for citator purposes, for validation purposes, you want to check the history tab. That's the litigation chain that talked about in the video. So see what happened to this actual case, Rush Prudential. And as I mentioned, you see that nice little map like we saw on Lexis. So you can see the chain to see if your particular case was overruled by your court or reversed by your court. And then the other tab you want to make sure to check is negative treatment. Again, this is for validation purposes. If you are validating or invalidating a holding, you want to look at negative treatment. And Westlaw is just confirming what we saw on the map, that there is no negative direct history. By direct history, they just mean in your litigation chain, that concept we already talked about. And then here are the negative other cases. So here's overruling of Rush Prudential was also recognized this other case, Glynn versus Bankers, and we already looked at the Clay case. So that is what you want to look at for validation purposes on Westlaw. Just for point of information, you can see these cases. This is telling us here on the right that these headnotes these headnotes in Rush Prudential are discussed in this Glynn case. And if I put my mouse over the headnotes, I find out which headnote number 1 is in the Rush case. So if we go back to the Rush case, I would see it covers insurance and states. I would see headnote number 3 also covers insurance and states. This is that depth of treatment, same concept we saw in Shepard's. So again, same ideas, it just different part of the screen and looks a little bit different. Okay, so that's the validation portion of KeyCite on Westlaw. Let's go back to our case and talk about the research portion of the Citator on Westlaw. And it's pretty much, again, the same as Lexis, just looks a little bit different. So if we look at the headnotes back in the case, we can see other headnotes that cite to our case for that particular headnote, or other cases that cite to our case for that headnote. So if we know what headnote we're interested, just as we found the GPS positioning headnote in the video. So if we decide, oh, this is a great headnote for us, discusses our issue in Rush Prudential, I can go to other cases that cite that headnote and again limit by jurisdiction and do all the things we did on Shepard's. So that's one research function that Westlaw provides for us, just as Lexis does in the headnotes. The other would be in citing references. I'm going to go directly to cases, and I want to do that. I want to choose a particular content type because then I get all of my filters. And by my filters, we are actually already familiar with them, but to show you. So again, we see our citing references. We've already looked at this list a little bit already. It's actually much longer than the negative treatment. See, 30 versus over 3,000, so we won't see them in the same order. So I don't see that Clay case up so far. So these are all the citing, not just the negative. Westlaw surfaces the negative on top because they figure that's what you're most interested in, but for research you might be interested in positive as well. So we could look at treatment status filter for that, and again I'm looking at cases. So if we take a look at treatment status, you can view only negative or hide the negative since we've looked at that already. We can look at depth of treatment, again how much the citing case talks about our case, talks about Rush Prudential. We saw that on Lexis as well. Obviously by jurisdiction is always can be of interest, just as we did on Shepard's, getting a Second Circuit case from a Seventh Circuit case. And the headnote topics. So we could specify, so looking at the case and clicking on that link under the headnote, we just go to that particular other cases citing for that particular headnote. If we wanted to say look at cases that cited with more than one headnote, we could click in citing references in the headnote topic filter, and I could scroll down here and choose a couple of different headnotes. So I just click on the box underneath the headnote I was interested in. So 18 citing references for headnote 3. I see 49 citing references. So again, ways of using KeyCite, the Westlaw features of KeyCite for research purposes. So using your Citator for research purposes. And we also have search within results, as you can see right here. The last feature I'll show you in KeyCite. That's also available on Lexis toward the top as well. You can set up an alert. This little bell symbol usually means you can create an alert. So if I'm following a case, and I've done this for a bunch of different research reasons, if a big case comes down and I want to see what happens, does it get appealed or it's on appeal, what happens to it, I can set myself up an alert. I can tell Westlaw or Lexis, email me results every day, email them every week, however I want to set it up. So that's a nice feature to know about. Okay, so that is Westlaw Citator KeyCite. Any questions? Let's take a quick look at BCite, or Bloomberg Citator. So I pulled up Rush Prudential here on Bloomberg just by typing in the name in the search bar. And as I mentioned, Bloomberg's citator is called B-Cite, and the B-Cite analysis is here on the right, and it pops open and it tells us, it also gives us treatment, how many positive, how many negative, and if I want to see the full report, I click on the signal here, and I see my different tabs. So I can see the case analysis, again, table of authorities, and citing documents. Any questions? Okay. So what I am going to mention, but admittedly not show you, is FastCase. FastCase also has a citator. And will tell you not only what cases cite to your particular case, but also the treatment of those cases. So you can use it for validation as well. There are tutorials on FastCase. So what I will tell you, on your cases assignment, which I'll be distributing at the end of class, I give you an optional question on FastCase. You do not have to answer it. It's for extra credit. And the way you will answer it, if you are interested, is to take a look at these video tutorials. But if you don't want to be bothered, then don't bother. But that's how you would... I did that in part because I don't think it's worth the time, because I don't know how many of you will use FastCase. I also did it because it's a good way to get practice on how to use a system you're not familiar with. Okay. So, at least for case opinions, I'm now going to move on to freely available, or websites that are freely available that you can find cases on. And of course, we've kind of talked about Google Scholar already with respect to case law. We definitely already talked about with respect to articles, but Google has more and more cases. And we'd actually taken a look at that back when we first started talking about cases. Google Scholar is kind of interesting because it also has a citator. So if I pull up our Rush Prudential decision, you'll actually see how cited. This is different than any of the citators we've looked at so far because it doesn't tell you how the cases are treated. So I see all the cases that were cited by Rush Prudential, but I have no idea if they negatively spoke about Rush, positively, just mentioned. It's just all the same. It's all cited. Kind of useful for research, but not very useful for validation. But you can just pull up a case. You can start your case research on Google Scholar. Again, you want to make sure to choose, I didn't highlight this before. If you are doing case research, make sure you highlight the case law, not articles, and then you can select your jurisdiction. So not a bad place to start. The thing with Google Scholar is that the coverage varies across jurisdictions, so you will not go back to the very first case, say, for New York State. I think it goes back to the beginning for the Supreme Court, but I'm not sure about the federal courts. So just be aware that you are not getting all the cases, and even though it's an old case, it still may be relevant to your issue. So that's Google Scholar. There are a couple of other sites. One of interest. Did I just close that? No, I didn't. Here we go. So one of interest, you're probably not going to make a great deal of use of yet, but it's worth knowing about down the line. Case.law, Harvard and a bunch of other people got together and tried to take the opinions of all of the case law and make them freely available. And they're making them available basically to programmers to do interesting things with them. So as I said, right now I don't know that it's particularly useful, but they are talking about ways of creating word clouds and all sorts of other funky case research tools. So as I said, worth watching. Another way to find cases freely available is to, and I mentioned this strategy before, get comfortable with a couple of portals. So this is FindLaw, and when I go to FindLaw, I tend to like to go for legal professionals because that's what we are. and Find Law will help you find cases. It will also link you to other sites that have cases. And those other sites might be the courts themselves. And that's also what my favorite portal, Legal Information Institute, will do. It will link you to the different courts that might link you to their decisions. And what that might look like here, what that might look like, for example, here in New York, here is the newyorkcourts.gov. So this covers all of the courts. So I could take a look at all of the decisions available from all of the courts. I could go to a particular court by the court locator. And if I did, say, the Nassau County Court, I could find decisions here. The only reason I would want to go to a particular court to look for its decisions is if I already had a decision in mind from that court and I just wanted to find it. And that most frequently is going to happen for a very recent case. Like, say, a case that was decided last week that may not even be on Lexis or Westlaw yet. And I have had that happen. So that's why I would want to know about going to a particular court's website to find a decision. And yes, you could just Google either the court or you could Google the decision and see if you find it that way. But there are times Googling the decision you won't find it. But if you get to the court and then get to the court's decisions and then follow their search, use their search capabilities, you can get to the decision that way. And here's an example of just going to the overall decisions for New York courts. We can take a look at official reports. We can take a look at slip opinions. And this is a site we actually looked at last time. And again, this is just an example of going to a particular state court to find a particular decision, which is most of the time how you would use this, why you would go to a court looking for a decision. And then the last thing I'll show you just as an FYI, since we're talking about citators, is at this newyorkcourts.gov, they actually have a citator. But it's the same thing as Google. It's a citator that doesn't tell you how the cases are treated, so you can find other cases that cite to your case, but you don't have no idea what they say about your case. And you just fill in the citation here. You can see the form. Okay, any questions about free websites for decisions? Alrighty. One couple of other aspects of cases, and then we'll take a break. Dockets. Way back when we first started in the beginning of the semester, I acknowledged that Bloomberg was not going to be particularly popular except for dockets. And here we finally are. This is where Bloomberg excels. It does other good things as well, but for our purposes, Bloomberg does the best job as far as I'm concerned. Whenever I get asked a question to find a particular document in a docket. Now, a docket is just the history of a case when it was first filed, so from the complaint on up through the decision. So if I want to find a complaint, if I want to find a motion, if I want to find a filing of a brief, I would go to dockets. And the reason Bloomberg is so good in dockets is that it basically has all of the federal dockets from the original source, which is called PACER. PACER is the federal source for federal court dockets. Lots of places have subscriptions to PACER. It is one difficult database to use. You'll have to take my word on it. So when all the federal court dockets went over to PACER, those of us who've been fighting with PACER for a long time were very, very happy because Bloomberg makes it much easier, and they are as complete as PACER is. And also, once you have a subscription to Bloomberg, it doesn't cost any extra, whereas PACER does charge every time you look at something. Not a whole lot of money, but still, if you have Bloomberg. So if I want to get to dockets, dockets is on the home page. It pops up this. And again, if you're looking for a docket, you already have a case in mind. You may have the docket number, which is a long string of numbers. I'll show you when we get there. Or you may not. So then you just want to navigate to your particular court. So I am going to look for basically the U.S. somewhere in the federal courts. And if this doesn't work, and then scrolling down, I can indicate. So here, if I knew the docket number, I'd put it in there, or I could indicate the party. Why is that jumping up? And I am going to look for a case involving Led Zeppelin. It's actually a famous copyright case, but I'm going to make sure. Okay, and 2. So let's take, those are dockets from different stages. Actually, this particular case has been appealed to the Ninth Circuit. So those first 2 dockets I scrolled past were the Ninth Circuit dockets. We're now looking at the District Court docket. I just thought this one would be more interesting. No other reason. So you can see what a docket looks like. The docket number I was telling you about is this string, and I usually don't search by docket number because if you don't get it exactly right with all the dashes and the zeros in the right place, you don't pull it up. So that's why I like to use party name instead. You see lots of defendants, and here's what a docket looks like. So you can see it started with the complaint. And then here we have, you might have summonses, we have a demand. Those of you who've taken New York or civil procedure will know some of these, affidavits. And here if I click on view, Bloomberg will show me that particular document as a PDF. So that's why we like Bloomberg. Bloomberg also has some state court dockets. It's not nearly as good. State court dockets are pretty tricky to find. I'll actually sometimes go to those court websites that I was just talking about for decisions for state court dockets. I usually won't go to Lexis and Westlaw. Lexis and Westlaw do have dockets, but it's very hit or miss. Any question about dockets? Same docket. So there's another free site called Recap. If you might notice, Recap is Pacer spelled backwards. That's because these folks are trying to capture Pacer for free. So Bloomberg has all of Pacer, but of course Bloomberg isn't free. These Recap folks are trying to get all of that docket information for free. They're only part the way there, but you can search and see if you find what you need if you don't have access to Bloomberg or Pacer. And last, in terms of case materials, are oral arguments. You can actually find both transcripts and audio files of oral arguments. So the most famous of these sites on the web is the Oye site. This is from the Supreme Court. And again, you can search through the cases to find, as I said, both transcripts of oral arguments before the Supreme Court as well as the actual audio files. It's kind of cool. You can go back and see actually some older Supreme Court cases as well as the current ones as well. This also exists in New York for the Court of Appeals. You can see the oral arguments webcast. So if you're interested in hearing oral arguments in the highest court in New York, it also includes transcripts and closed caption video, it says right here. Okay, so I don't expect you to remember all these sites, just if you can remember that this stuff is available, and then when the time comes that you need it, you can either try Googling or ask your favorite reference librarian. But this, especially the docket information, especially for those of you who plan on being litigators in whatever area, you will eventually run into having to find some docket information. Any questions? Alrighty then, let's take a break and come back at 5:50. Hops to daylight time. Don't worry, I won't say that too many more times. We've talked about court opinions and how to find them. We've talked about how to validate them or invalidate them, where to find them for free on the web. We've talked, the opinions are sort of the end of the litigation process. We've talked about how to find the documents throughout the litigation process, looking at dockets. And we're now going to look at court rules. So we're not going to spend a whole lot of time on court rules, not because they are not important, but because it's fairly straightforward in terms of what I think you should know about them. So court rules in this whole process fit in as a litigator. what you need to know as you are appearing before court. You have a handout which pretty much tells you everything you need to know. And no, I'm not going to read through the whole thing. So on page 1 is how to find it, a few free websites and the paths on Lexis, Westlaw, and Bloomberg. And pages 2, 3, and 4 give you more details about the different types of court rules. And what you really need to know and to try to keep straight is more conceptual, and that is that there are basically 2 types of rules. They're the procedural rules. So you talked 2 semesters about the rules of civil procedure, the federal rules of civil procedure and Civ Pro, and you may or may not be taking or have taken New York civil procedure, so the New York rules. These are the substantive rules of what happens in litigation. So statutes of limitations, how long do you have to bring an action? Other procedural rules you see on the handout on pages 2 and 3, so the rules in criminal procedure, evidence, sentencing, all of these are substantive and substantial rules that you learned about in those various classes I mentioned. And this chart shows you where to find them, which I'll talk about in just a minute. Then there are the other type of rules that are frequently referred to as court rules. And these are not substantive. These are more how the court operates. So how long can your brief be? Are there rules on typeface? We talked a little bit about one court rule, whether or not you can cite to an unpublished decision. So again, not affecting the rights of the substantive rights of the litigants, but still important for you as an attorney if you are representing someone in court. And you can be held responsible for not being aware of these court rules, which you certainly don't want to have happen. So the place you find these rules are as set forth. So for example, going back to page 1, for the substantive rules, so for the federal rules of civil procedure, for the CPLR in New York, so those are actually, well, the CPLR is actually enacted by the legislature. The federal rules of civil procedure are developed by a commission and the judge, but it's a very official process. And you find these frequently within the statutes of your particular jurisdiction. So taking a look here for federal, the USCA, I'm looking at the table of contents. And what's good to know about these rules is that they frequently appear as appendices to the particular title that they are related. So, by that I mean, so there's the judiciary title, right? So judges sit in courts. So the Federal Rules of Civil Procedure is an appendix to Title 28. And you can see that, not so much I expect that you'll use the books, but if maybe this helps make it make more sense. So after the sections of the U.S. Code for Title 28 come these volumes that just say Federal Rules of Civil Procedure. So these are not statutes, but they're within the statutory code as a service to attorneys. So another reason why it's called annotated, because added stuff is added or annotated to it. Again, I don't know that too many people will be looking for the FRCP in the print USCA, but there it is. So likewise for New York, actually, as I mentioned, the CPLR is passed by the legislature. So the CPLR is its own title in New York. So just taking a quick look at that. And it would look the same in the table of contents on Lexis as well. So you see actually Westlaw pulls it out for you, but it would also be civil practice law and rules. Again, so those are the substantive rules. The court rules, how the court operates day by day, you will find frequently in appendices. So kind of at the end, so appendices, just like I said, Title 28 for the FRCP, there are other appendices to Title 28 that'll have these special court rules. So you will have particular rules for the Second Circuit, for the Supreme Court. You'll have particular rules, sometimes judges even have their own rules. And they get very specific about how the judges want to operate in their court. And you need to know those as much as you need to know the FRCP or the New York CPLR. So here you see on Westlaw, the CPLR is statutory, the court rules are here at the very bottom, or they appear in just a separate volume here. And again, most people aren't going to be looking in the print anymore, but if this helps you understand that the rules are just separate from the rest of the statutes, but still related to the set, is probably the main point to remember. Okay, so that's what the different sets of rules are. That's a beginning on how to find them. As you see on pages 2 through 4, a lot more detail, federal and state, about what the rules are, where you find them in print, online, and also on pages 2 through 4. So 2 and 3 are the substantive rules I talked about. Page 4 are the more specific court rules. And all of those boxes will also give you secondary sources to help you understand those rules. And again, for those of you planning on being litigators, you need to know these rules and you need to understand them, both the more substantial procedural rules as well as the more operational specific court rules. Lots of states have secondary sources specific to that. So here in New York, you'll want to know about New York Practice by Siegel. You may even have one of his books for some of your courses. Other states, if you run across a treatise, Massachusetts Practice, Connecticut Practice, when you see a treatise with the word practice in it, it frequently, I can't say always, but it frequently will be a guide on both the procedural and the more operational and court rules. So definitely look for those secondary sources again to help you understand practice in those areas. And as I said, the handout will give you more detail. I'm really not going to go into more detail or ask you to know any more detail than that, but maybe the handout will help you at some point. Any questions about court rules? I know that was pretty quick and very broad, but again, as long as you understand what they are and that you do need to know about them, that's the important part. Okay, so we've talked about what you need to know about going through the litigation, the documents you find in a docket throughout the litigation. A couple of aspects that you need to know about at the end of the litigation process has to do with jury instructions and jury verdicts. And these are worth taking a quick look at from a research perspective because you will need to make recommendations to the judge once you get to the end of your trial as to what instructions you want the judge to make to the jury. And of course, you're going to want those instructions to be as favorable to your client as you can. And you'll also want to make recommendations should the jury verdict go either way, what that verdict should be, specifically how much in damages. This should be of particular interest to those of you interested in personal injury. So you need to know how to make those recommendations. And of course, there are research resources for you to do just that. And I'll highlight a couple of the best ones for you here in New York, as well as how to find elsewhere. So I'm going to start with criminal jury instructions, only because, kind of interestingly, For jury instructions in criminal cases here in New York, they only exist online. They don't exist in print, and they're actually freely online. So you could just Google New York criminal jury instructions, and it should bring you to this page. And just so you can take a quick look at what I am talking about. So here's a table of contents. So here are recommended jury instructions for these particular issues that will come up within criminal court. So what would you recommend to a judge if you were either representing the defendant or the prosecution in these particular offenses? So that's for criminal. For civil, here on Westlaw, we'll start with. As always, a good place to start is just in the search box when you're looking for a particular resource and just start typing it in. So I'm just typing in at the very first page, jury instructions. And one reason I'm doing this is that this came up when we were doing our research, our case workshop last time. Some of you were very rightly typing in attorney malpractice, and you were getting these questions. And so these questions are Westlaw's, one of Westlaw's applications of artificial intelligence, where it's trying to guess the question you're asking and then give you the answer to your question. So that is what Westlaw is doing with regard to jury instructions. So it's asking, when are jury instructions improper? So if I clicked on those links, that would get me an answer to those questions. So you just want to be, again, aware, our bibliographic awareness theme for the course, of what's going on here, because a few of you understandably got confused and clicked on those questions and then couldn't get to the point of the case research that we were doing for the workshop. So of course I'm typing in jury instructions. I don't want those questions. I want to find jury instruction resources. So what I am going to do instead is specify a jurisdiction, because usually when you're looking for jury instructions, unless you're writing a paper on it, you're going to be interested in a particular jurisdiction. So here in New York, if I start typing in New York jury instructions, I will see what we call PJI. If you hear, you're going to hear, especially if you're a litigator, you're going to hear, go to PJI, go to PJI. That is the place to go for New York civil jury instructions. If obviously you're interested in other states, you can type in those other states. So here, if I start with Florida jury instructions, you'll see what you get. So here we see Florida standard jury instructions. But I'm going to go back to PJI for a couple of reasons. So here, back at PJI. So PJI does a couple of things. Actually, I mentioned this way back in the beginning. PJI is actually a really great, quick and dirty secondary source. So we're going through this whole class and we're going through all the details of all the different places you could check right into the worst of it, legislative history. There are going to be lots of times, depending on your practice, maybe most of the times, where you don't have time to do that kind of in-depth level of research. You just need a quick answer. And yeah, Google's okay, but as we've already discussed, you got to be really careful about Google, because you don't know what the site is, what their perspective is, how accurate it is. PJI is a great place to go if you need a quick and dirty answer on something. Now, I can't promise you you will always find your quick and dirty answer in PJI, but that would be one place, maybe before, maybe after New York jurisprudence, that I would check out. And I will show you why. So here we are in New York pattern jury. Now, if I wanted a quick and dirty answer on our question from last week, attorney malpractice, within PJI, I'm searching. And so here we see the title, malpractice attorney. Let's dive in so you can see what PJI looks like. So here are the sample jury instructions. So here's what I might want to submit to the judge as what I would like the jury instructions to be. So, and here's the text. But then it goes on to tell me to establish a particular, CD is just a fill-in for a particular person's liability for malpractice, plaintiff must prove a preponderance of the evidence. So I'm already getting a mini tutorial on how to prove attorney malpractice in New York. And then there are these comments. So it tells me about, it gives me a caveat that the charge incorporates the principle, and then it gives me references to cases. So this is a classic secondary source where it gives me an explanation, granted a fairly basic one, and then gives me references to primary sources, in this instance to cases. I have heard attorneys on panels and whatnot say that this is what they do. So this isn't just me making this up. This is attorneys who find this really useful when they just need a quick answer. This is where they might go. And even as I go down further, I see, in general, an action for legal malpractice requires proof of 3 essential elements. So I'm learning, and it's now going to list for me the elements. It's giving me cases about those elements. Then I can find out more about the attorney-client relationship. So this may even be more than just quick and dirty. So again, PJI, a great source for quick research on a particular area. Might be true for other states' jury instructions. That I don't know. I haven't investigated those. Worth looking if you wind up in another state. But if you do stay here in New York, remember PJI if you can. As well as, of course, for getting those sample jury instructions if you need them at the end of a particular litigation. There are other jury instructions available on Westlaw, excuse me. I'm combining the two. That's kind of funny. So here under secondary sources, we see jury instructions. So there are jury instructions for federal courts as well as other state courts, as I mentioned. And you see what's available on Westlaw here. So as any questions about PJI New York or jury instructions on Westlaw, here back on Lexis. Actually see a link right here on the home page to see what Lexis has available. Lexis does not have PJI, so that is one big advantage of Westlaw, and that's because I'm pretty sure PJI is published by West. So you don't have great New York jury instructions on Lexis, unfortunately. So I will instead show you a different state's example. So if I do, I'm just back at the home page here, and using our example, not typing very well as usual, but using our example of attorney malpractice. I'm searching everything for the moment. So again, I can choose jury instructions here and filter that way, my pre-search filter, or I'm choosing to show you a post-search filter just to show you that jury instructions are available as a post-search filter. And that's true on Westlaw as well. And then I can filter to the particular state, and you'll see that we won't find New York here. As I mentioned, Lexis doesn't have New York, but it does have Florida. So we see here Florida standard jury instructions is Florida forms of jury instruction. So you could find out about how you might want to recommend instructing a jury in Florida, and take a look and see if this is also good for just giving you some background on that particular issue in Florida. And likewise on Bloomberg, kind of sketchy on jury instructions. So again, the same strategy. If we type in the search box what we're looking for, Bloomberg will begin to pull up. And I find it better, again, with jury instruction, because it's usually a particular jurisdiction, to put in Florida. And there you. And Bloomberg, like Lexis, doesn't really have anything good for New York. So that's a quick guide to jury instructions. Really, the best thing to remember if you're in New York is PJI. If you're not in New York, find out what the favored manual is for jury instructions from a practitioner, from a legal research guide. Okay, and last but not least for today, so we've got the jury instructions, but what about the jury verdict? You are frequently suing for something, right? Sometimes it's specific performance, but sometimes it's just plain old damages. How do you know how much damages to ask? You take a look at jury verdicts. So going back to Westlaw here, we go back. Actually, for some reason, jury verdicts is on the home page. For jury instructions, you have to go to secondary sources. Don't know why that is, but so you could specify jury verdicts and then go to your particular jurisdiction. And again, filter before, however you want to do it. So I'm going to New York, and then I'm going to search and see what we find for legal malpractice, so you can see what jury verdicts look like on Westlaw. Now, one kind of interesting thing, there are the filters. They're going to look quite a bit different than the filters we're used to looking at. I mean, yes, there is jurisdiction, but there's actually a word range. So we could see if we wanted to search cases to see if they were like ours and see, are there cases, say, 2 million to not quite 5 million? So there are 2 cases. We could take a look at the 5 million case. That's always fun. And then apply. So I'm now filtering through cases on legal malpractice where the verdict was for 5 million or more. So read this and weep, future attorneys. Because somebody was found liable for malpractice for over $5 million. So actually for jury verdicts, Lexis is more interesting. And Lexis is more interesting because it provides us a verdict settlement and analyzer, and that is up here next to research. Now you could use the regular research box and find jury verdicts that way, but this verdict settlement and analyzer in the little box to the left is a lot more interesting and I think useful. So we're already narrowed to verdicts. And I'm already filtered to New York because it remembers what I did last time. And I do recommend you doing that, again, depending on, and most of the times you would want to, again, because you're looking for verdicts in a particular, oops. And I'm going to add legal malpractice and research. See what happens if you find anything about awards having to do with legal malpractice and research. And one reason it's this verdict analyzer is more interesting is it gives us some of this chart information which may help. So I don't know, number of cases by resolution, number of cases per year, but you get a sense of the award range in dollars, where the verdict was for the plaintiff, the median award, the average award. So the percentages here, case by resolution. So most cases here were settled in this area. There was a plaintiff verdict. I'm sure you can't read that number. It's 32%. So you get some overall information. And then you get the actual cases with the verdicts themselves. So scrolling down here, so this is again a legal malpractice claim, and going through, it'll give you the name of the counsel, summary of the case, how long the jury took to deliberate, that's kind of interesting, the length of the trial, experts, and the award, which was $8 million. So again, I'm showing you the sensational one with the big awards, but hopefully you can see if you're in a case and you need to ask for damages, you want to be able to justify what you're asking for, or even just to get a sense if you don't know what to ask for. You can search for your particular cause of action in your jurisdiction and narrow using the filters accordingly. Any questions about jury verdicts? Okay. So we are done for today.